call the first case, 116307, Corvias Military Living LLC et al., the Eventomatic and Yekel Inc.
Your Honor, may it please the Court. I'm David Rogers, again, on behalf of Petitioner Yekel Inc. In this case. I would like to request at the beginning 3 minutes of rebuttal time at the end, and I'll take all of those 3 minutes. I think, as the Court may be informed, Mr. Lowry and I will be splitting the initial time there 6 minutes apiece, approximately. That's okay.
3 minutes is granted.
Thank you, Your Honor. Your Honor, this is a civil case, product liability case, coming to you from Geary County through the Court of Appeals. It's a product liability case involving the application of the economic loss doctrine. It involves a building project at Fort Riley, which involved the construction of approximately 1,200 homes and the installation of some 3,700 bathroom fans. Those are the products that are at issue in this case. While there were 6 defendants below, 4 settled, 2 filed for summary judgment and obtained summary judgment from Judge Sexton. The case went before the Court of Appeals, which reversed. We petitioned the Supreme Court for review, which brings us here today. Kansas courts have been applying the economic loss doctrine to product liability cases for over 20 years now. The case before you today is a product liability case involving what everybody agrees is $459,000 of economic loss. There is no law or reason why the economic loss doctrine should not be applied to those losses in this case. The case before the court this morning also involves $50,000 of property damage to the homes into which the Venomatic fans were installed. And depending upon the application of the integrated systems rule, those damages may also be economic losses. If the integrated system rule applies, then the case should be over, as all damages are economic losses barred by the economic loss doctrine. If the integrated system rule does not apply, then this case should be sent back to Judge Sexton for further trial on the $50,000 of property damage. Further setting the table, Your Honor, from a fact standpoint, my client manufactures very small motors, and the motors involved in this case were actually manufactured between 1999 and 2001. Venomatic then took those motors and put them into bathroom fans, and they were then installed into the homes that I mentioned before. Corvias, the plaintiff below, the respondent here, builds and manages military housing developments across the nation. The project at Fort Riley, as I said, involved the construction of 1,251 homes and the installation of 3,785 bathroom fans. In June of 2012, and then again in January of 2013, approximately 10 months apart, there were 2 fires that allegedly involved 2 of the fans that were installed into the Fort Riley project. Plaintiff is making claim as it relates to those fires for $50,656 for property damage to the homes themselves. Plaintiff is also making claim for $459,026 for the removal and replacement of every other fan installed at the Fort Riley project, none of which malfunctioned, none of which caused a fire, and none of which were tested by anybody to determine whether there was a problem with those fans.
Just a factual clarification. Were the motors that your client manufactured specifically for the Ventmatic product, or were they pre-existing prior to Ventmatic utilizing them for their fence?
It's a great question. My understanding, Your Honor, is that those are multi-use motors. They
So
could be
they're
used
used
for
in
others.
multiple different
Yes.
applications.
But I do believe, Your Honor, just to be completely frank, that they're used most commonly for bathroom fans like this.
Okay. And do other manufacturers of vent fans utilize your motors? You know?
Don't know. Off the top of my head, I do not know, Your
Okay.
Honor.
Thank you.
Corvias, when it began the project in Fort Riley, entered into master of service agreements with its subcontractors. In those master service agreements, it demanded warranties from the subcontractors for material and workmanship and things of that nature. As it relates to the fans, the two subcontractors were Fonistock and United, both of which were defendants below, both of which settled and are now out of the case. There were also two other defendants, 6 total, as I said before. Before the fires in question, plaintiff Corvias claims to have made over 100 warranty claims on these very fans that were installed at Fort Riley before the fires in question, and before the removal and replacement of the fans, with the costs of which total $459,000. There's no question, plaintiff has argued quite clearly that these are product liability claims. They're nothing else. And as such, they are governed by the Kansas Product Liability Act from 1981. The basis for the economic loss doctrine and its application to product liability cases arises from the Kansas Product Liability Act. In determining what harm is under the Kansas Product Liability Act, the legislature determined that consequential, direct and consequential economic losses from harm, that one may never recover for those under the Act. If you have economic loss, then your claim is not a product liability claim. If you are bringing a product liability claim, it is governed by the KPLA, and you may not claim economic loss. That is the foundation for the Northwest Arkansas case that we've talked about so much, the Jordan case, and the Koss case, those 3 cases from 1999 through 2001, as it relates to the economic loss doctrine. The economic loss doctrine in product liability cases is founded upon the Kansas Product Liability Act.
Does that mean that there wouldn't be, the analogy I keep trying to play with in this case is the difference between an installed window unit and the fan that's involved and a light fixture, and I'm trying to figure out how the analysis would change depending upon which of those items we were talking about in a building or a house.
As it relates to the integrated systems rule, Your Honor,
Yeah.
and that is of course what the Court of Appeals focused on, and I want to address that question, but I want to point out that Judge Sexton, before he got to the integrated systems rule, determined that the $459,000 of removal and replacement were economic losses and were barred by the economic loss doctrine. He then turned to the integrated systems rule, and as you know, he determined that these bathroom fans were integrated into the homes at large. The example that you just gave, Justice Biles, is exactly the Babe Reeves case versus Norco Windows case that came out of Wisconsin. And in that case, the court determined, the Wisconsin court determined, that windows installed into the house, which were defectively manufactured and caused leakage, were integrated into the home itself, and therefore damage to the home constituted economic loss as well. In this case, as it relates to the bathroom fans, and we've argued this at length in our briefing, there isn't any question, regardless of what standard you use, we believe that these bathroom fans were clearly integrated into the home at large. And if that's the case, then the $50,000 of property damage to the houses are also economic losses. And the reason we've argued that, Your Honor, is that if you determine that the right application is whether these are integral to the functioning of the home, the truth is people could not move into these homes unless the bathroom fans were there.
And that's your building code argument.
Building code argument. And that's also, by the way, been adopted, that particular building code, I think it's the International Building Code, it's also mandated by the federal government as it relates to federal housing. So we believe that not only is it integral, that is it subsumed into the home, it also becomes a fixture of the home under real estate law as well. So whether it's integrated into the house via the theory that it's subsumed by the home itself or becomes integral to the functioning, we believe that both of those involve integration of the product into the home.
But why is the building code argument legitimate? I mean, I understand when we're talking about the functionality of the product, but how do you get to sort of regulations that control the functioning of the product? Because those are different. I mean, I can move into a house that doesn't have, or I can be in a house and the house will do what a house is supposed to do. The city may not want me to live there, but the product works.
Well, in that it provides shelter from rain and storm, that's true. But as the corporate representative for Corvios, the respondent here said, it's a matter of health and welfare. That the reason these bathroom fans are important is because they move moisture, and when they don't, the air becomes filled with mold and they become dangerous. That's Corvios'
So what's your
testimony.
best case on the building code justification for this? Your best supporting case?
Yeah.
Case law authority.
Yeah, in terms of Kansas law, applying the building code issue as it relates to building fans, we've cited the code itself, and it's in the fact that the Junction City has adopted it. I don't know of any case in Kansas like this, which has determined that because of that, it's integrated into the home itself.
So what about a secondary jurisdiction? May not be controlling or persuasive because it's from here, but do you have? I'm trying to remember whether you had any case law support for your building code argument, drawing from the rest of the country.
Yeah, what we cited to you in the briefing, Your Honor, was both statutory from the federal and the International Building Code and Junction City's adoption of the both of them. Your Honor, I do want to make clear that the way, I notice I'm out of time, Your Honor. Can I sum up very quickly?
Can you do it in 30 seconds?
I can, Your Honor. What I want to remind the court is that, and make sure it's a part of my argument, is that the $459,000 is determinative on its own. The economic loss doctrine applies to those damages, whether or not the integrated system rule applies to the damage to the homes themselves.
Counsel, I know you're in your 30 seconds, but I'll interrupt because I had a question about that $459,000. Procedurally speaking, what happened to that ruling, to the district court's ruling in that regard at the Court of Appeals?
With all respect, I can't tell.
I can't either. That's why I asked the
Court
question.
of Appeals is completely silent to that.
So
it analyzes the integrated systems rule.
So
and then says
if
nothing
that, what should we do about that? I mean, typically we would, or at least we would consider a remand to a lower court to decide questions that it should have decided the first time around, but didn't.
Well, I think you can take care of that itself. What we're asking the court to do is either find that the $50,000 is integrated, or send this back to the district court to Judge Sexton for trial on the $50,000 of property damage. But Judge Sexton ruled that those were barred by the economic loss doctrine.
I understand. I'm just trying to figure out what we do with the fact that we've got a ruling in the district court that was appealed and not decided by the Court of Appeals.
I think that this court has the jurisdiction to send the entire case back for trial, depending on its attitude toward the integrated systems rule. And I believe that it can rule that the $459,000 is economic loss. I do not think you need to remand to the Court of Appeals for that purpose.
Just as a matter of judicial efficiency, we should rule on that. That's your position.
It's certainly before the Supreme Court. And its silence at the Court of Appeals was why we petitioned for review on that. One of the main reasons we petitioned for review, because the Court of Appeals was silent on that issue.
Okay. Thank you, counsel.
Thank you, Your Honor.
Oh gosh, I'm sorry. May it please the court, I'm Seth Lowry. I'm counsel for Venomatic Ltd. And before I begin, I'll graciously cede my time to Mr. Philbrook if that would please the court. In this case, I believe Mr. Rogers has ably summarized how we got here. Two malfunctions of two allegedly defective bathroom fans prompted Corvias to implement a private involuntary product recall of 3,783 same model fans. The Court of Appeals, on its own initiative, unnecessarily modified Kansas law to hold that the fire damage involved in that case in the two fires was recoverable in tort, but failed to address the undisputed economic losses for the removal and replacement of the 3,783 allegedly defective, non-malfunctioning fans. The district court found that the removal and replacement costs were barred by the economic loss doctrine. And I wanted to take an opportunity to answer your question, Justice Stiegel, of how this court can address that claim in particular. Judge Sexton was very clear. If the court looks at least as it regards to his summary judgment memorandum on the summary judgment motion filed by Ventamatic Ltd., on page 6 of his summary memorandum in order, he specifically found that for approximately $459,000 for removal and replacement costs were barred by the economic loss doctrine because those were undisputed, pure economic losses. He then proceeded to analyze the integration systems argument as to the two fans that allegedly malfunctioned and caused the fire damage. Corvias, in their appeal, really only focused on the integration argument as to the two allegedly defective fans that malfunctioned. They left, as far as I can see, undisturbed Judge Sexton's order that the removal and replacement costs were pure economic losses that were barred by the economic loss doctrine. And as far as it stands before this court today, Judge Sexton's ruling is unappealed.
So yeah, you're making a different argument now. You're saying lack of preservation. And you're saying that 450 whatever thousand is not even properly before us.
I would make that argument, yes, Your Honor. And the best that Corvias had at the Court of Appeals was that they tried to make an argument that the removal and replacement costs were somehow symbiotically animated and attached to their viable claim under the Kansas Product Liability Act for the two fans that allegedly were defective and malfunctioned to cause the fire, or to cause the two fires. And that argument is a bit confusing.
Did you make a lack of preservation argument at the Court of Appeals?
We did not, because Corvias's brief focused entirely on the integration argument and focused on that. So there was no argument about Judge Sexton's ruling as to the pure economic losses. We did say in our briefs that Judge Sexton's ruling on that point was, well, at least we did say in our briefs that Corvias has admitted throughout the proceedings in the district court that those were pure economic losses. And that point was never contested by Corvias during the proceedings before the panel of the Court of Appeals. Now, the argument about the merger argument under the Kansas Product Liability Act is a bit puzzling for a few reasons. First of all, being that Corvias did make an implied warranty claim against both Yakel and Ventamatic Ltd. In the case, but it appeared that the nature of their product liability claim was a tort-based claim. And Kansas law has been very clear that there's a distinction between contract-based implied warranty claims and tort-based implied warranty claims. And the tort-based implied warranty claim that appeared to be asserted against both of Ventamatic and Yakel in the district court below appeared to be tort-based from all appearances. And it appeared that that was a fallback argument of sorts, meaning if we lose on the economic loss argument that the fire damage to the two homes caused by the two fans is pure economic loss, then what we have to do is we don't have privity with either the fan manufacturer or the motor manufacturer. We have to prove that these fans are inherently dangerous, because that's the only way that we can recover economic losses under an implied warranty theory. So they pursued that as a fallback argument. And
can you recover economic losses for the inherently dangerous product under the Kansas Product Liability Act? Or do you have to proceed under some other cause of action?
It's a very good question.
Because the Kansas Product Liability Act excludes economic loss, period. So that's my question, why are we even talking about inherently dangerous products?
That was part of the reason we were confused by that claim as well. And Justice Siegel, you hit the nail right on the head. The Kansas Product Liability Act excludes very clearly and unequivocally economic loss, both direct and consequential. And Corvias's argument has been that if they have a viable KPLA claim, that they can recover both their non-economic losses, either physical injury or damage to other property, and their economic losses, which the KPLA unequivocally excludes.
Well, and then I guess my last follow-up on this point, because the lower court undertook an inherently dangerous analysis, can we read into that the lower court construed that portion of the claim as something that was outside the Kansas Product Liability Act? Or is that a step too far?
That may be a fair inference. I would argue that if you look at the substance of the claim asserted in the pleadings, that Corvias's implied warranty claim does appear to be more tort-based than contract-based. I would agree that it really should be a claim under the UCC because as it relates to the 3,783 fans that they claim were defective but never malfunctioned, that is a quintessential case of economic dissatisfaction with a consumer product that you pursue through a warranty claim. And as Mr. Rogers pointed out, Corvias has done so. They're a sophisticated entity that had a quite lengthy master contractor agreement with their contractor, which in turn had agreements with the subcontractors, which provided warranty protection. And Corvias asserted over 100 warranty claims against 4 various fans that they were dissatisfied with. And if they were dissatisfied with the performance of these 3,783 fans that they think possibly were defective, they could have asserted warranty claims to pursue that recovery.
Counsel, I see you're out of time. Would you also like 30 seconds or less to wrap up?
30 seconds, Chief Justice Nuss. I appreciate that. The court should reverse the Court of Appeals and affirm the district court on the integration argument. If so, that's the cleanest, efficient way that disposes of this entire case. If the court concludes the bathroom fans are not integrated, then Corvias has a viable product liability claim for $50,656. The remaining removal and replacement argument, or the remaining removal and replacement claim, seeks economic losses that are unrecoverable under the Kansas Product Liability Act as a matter of law, or because they should have pursued such recovery under an implied contract-based implied warranty theory. For that reason, we'd ask that you reverse the Court of Appeals. Thank you.
Any more questions? Thank you, counsel.
May it please the court. Now it's my turn. Charles Philbrick on behalf of the plaintiffs Corvias Military Living and Corvias Military Construction. I was going to start with a discussion about David versus Het and then move into the defendant's arguments, but I want to go right to the questions about the economic loss doctrine's role in the Product Liability Act. All of the arguments that you've just heard are based on false premises. False premise number 1, that Judge Sexton found that Corvias could never recover the removal and replacement costs of the fans that hadn't caught fire yet simply because they were economic losses. That's not what he held at all. What he said in the first oral argument, which is volume 4, starting at page 57 of the record, he said, plaintiff is correct, he was referring to arguments that we were making about this point, that if you have a claim, these are not separate. He's talking about the damage from the fire and the removal and replacement costs. That if there is one, this claim, that is being presented is a total damage claim. And if one of these claims, if any of that damage slides under the product liability, the entire matter goes under product's liability. He's precisely right. If there is some damage.
So you're, by that statement, are you telling us that your entire cause of action was proceeding under the Kansas Product Liability Act?
No.
Well, okay.
We were hedging our bets. We pleaded out separate counts. We have the count under product liability. We had breach of express warranty, breach of implied warranty, and a Magnuson-Moss claim. And under the Product Liability Act, a product liability claim includes, not limited to, includes a claim in which there's a product that's unreasonably dangerous that causes harm. Harm excludes economic losses by either direct or indirect. But if you do have harm, then all claims, be they negligence, strict liability, express warranty, implied warranty, all those claims are merged into one unified claim, and the remedies associated with those claims are available to a plaintiff that can prove proximate cause. And what we contend here is that, yes, we had fans that weren't working, and we sought our commercial remedy, about 100 of them. If you look at Keating Declaration Exhibit A, you'll see the spreadsheet describing how these fans were simply not working. Over 100 of them were either making too much noise or they failed to operate, and they were removed and replaced, and those were warranty claims, and they were addressed. So many that we just stopped using them. But later, these fans started to catch fire and burn and damaged homes. Fortunately, no one was hurt. But they are unreal, and we have summary judgment evidence from our expert that these products contain 2 design defects that rendered them unreasonably dangerous for the purpose in which they are intended.
So let's go back to the removal and replacement costs.
I'm getting there. I'm just
are you conceding that those are economic losses, or are you arguing that they're not, that those
we
are not
concede
economic
that they
losses?
are direct economic loss.
So how can they be recovered under the Kansas Product Liability Act?
Because a plaintiff asserting a claim in negligence or negligent design is required to mitigate its losses.
I understand
Those
that.
are
I'm just
reasonable mitigation costs. We have.
Counsel,
Yes, I'm sorry.
I'm not able to understand the points you're trying to make when you're talking over my colleagues' comments. If you think you have something important enough to say, i.e. trying to persuade me of something and I can't hear it, you might want to reconsider your tactics.
Yes, sir.
All right, thank you.
Yeah, just the last question. I would just ask you to address specifically the language in the statute that appears to me to exclude, just on its face, on the plain language, it excludes recovery for economic losses under the Kansas Product Liability Act. And you've just, I think, conceded that $450,000 is an economic loss. So I am having a hard time understanding your argument as to how you get over the hurdle imposed by 603302.
The definition of product liability, a product liability claim, starts with the word includes, as in not limited to. It then essentially articulates the economic loss doctrine, which says that if a product liability plaintiff has only suffered economic loss, then it has no product liability claim. But if that product liability plaintiff has suffered either bodily injury or property damage to other property, to damage to property other than the product itself, then that plaintiff is entitled to proceed in product liability.
Can you tell me where in the statute it says that?
It's right in the definition of product liability, Section 2. Product liability claim includes And then it articulates the language.
And that's in
of the-
subsection C, and subsection D defines harm.
Right. And
And it
within
excludes economic losses from harm, period.
from the definition of harm, meaning that you have to have some injury or damage in order to proceed in product liability, be it negligence or strict liability.
So if you
But
have
it doesn't-
$1 of damage to property, then you get to bootstrap in all your economic losses. That's your argument.
Precisely, and the legislative intent for that is clear, because all claims in the section above, section C, says that when you have harm, then all claims, be they implied or express warranty, negligence, strict liability, are all merged into one unified claim.
And is there a Kansas case that construes 60-3302 and says that?
There is neither a case that says it the way I say it, or a case the way the defendants say that. But think about it. A product liability plaintiff that suffered bodily injury and as a result has lost income, the loss of income is direct economic loss. And that product liability plaintiff is entitled to recover lost wages in a product liability claim. Of course, a business that has a flood and has had a business interruption loss as well as damage to property is entitled to recover in its product liability claim, be it a negligence claim or strict liability, for the damages associated to the property as well as the value of its business interruption. The burden for the plaintiff is to simply show causation between the defect and the damages, be they personal or physical or economic, but they're still recoverable as long as they're causation. The appellate court agreed with us. Judge Sexton agreed with us on that. In the appellate court, the reason why it did not address the inherently dangerous argument is because once Judge Sexton found that the economic loss doctrine, by virtue of the integrated systems theory, applied, we still had express and implied warranty claims against Ventomatic, but we don't have privity. One of the exceptions to the privity requirement is that the product is inherently dangerous. But because the court found that we do have a product liability claim, therefore, all of the claims get merged into it. It did not need to address.
If we disagree with you on that, or disagree with your characterization of the lower court's rulings, what happens to your warranty claims, in your view? Are they still alive under a contract theory?
Yes, because one of the exceptions to privity requirement is that the plaintiff had suffered injury or damage.
But no lower court has ever ruled on those claims as contract claims. Am I right about that?
The Judge Sexton ruled that because all of our damages are economic losses, then we have no product liability claim. And then we have no warranty claims because we don't have privity and the fans are not inherently dangerous as manufactured. So all of those claims died based on that.
And what happened to the ruling, the fact finding, that the fans aren't inherently dangerous? What happened to, was that ruling appeal? I mean,
It was
the
appealed.
Court of Appeals didn't rule on that, did it?
It did. If you look at the very end of their opinion, they specifically point out that that issue is now moot because they have found that Corvias did suffer damage to other property. And as a consequence of that, all of those other claims are resuscitated, the dominoes are lifted back up, and then under the Product Liability Act, they're all merged into one single claim. And then it's up to the plaintiff to proceed at trial to prove causation as to all of its damages. I apologize for interrupting.
No, thank you. I appreciate the back and forth.
Let me turn us back to David versus Het, because I think it underscores some important points in this case. In David versus Het, this court determined that the economic loss doctrine does not apply in construction defect claims by a homeowner against a contractor, and that the economic loss doctrine wouldn't apply to those negligence claims, even if the homeowner only suffered economic losses. And in doing so, the court underscored the need to do an independent duty analysis in order to determine whether a claim is one that's really tort-based or whether it's contract-based. And when you do that, my time's running short, so let me get right quick here. Judge Sexton did something that a lot of other judges have done, which is he declares outright from the beginning of his discussion, this is a commercial dispute. He then went about employing the economic loss doctrine and the integrated systems theory in such a way as to make it a contract dispute and not a claim in tort or negligence. But if you do an independent duty analysis, this is clearly a negligence tort claim. It has been the duty of manufacturers in Kansas for 50 years that they owe a duty to the general public to manufacture products that are reasonably safe for the intended purpose. And when they design a product that has design defects that render it unreasonably dangerous for the intended purpose, they breach that duty that they owe everybody, including my client. And that's exactly what we have here. We've got bathroom ceiling exhaust fans that have two design defects that make them unreasonably likely to ignite and be the cause and origin of fires. And when you have that, you have something radically different than disappointed commercial expectations. You know, when the fans weren't working or they're making two noises, that's different. That's disappointed expectations. But when they catch fire and they burn and they could potentially kill people, totally different story. And that's what we have here. And that's why my client immediately, upon having the second fire, turned all the other fans off. They had a risk that other fans could catch fire and burn in the homes of people and families.
They had notice of risk. When did they understand? When was the expert report generated as a result of litigation, or when did they acquire knowledge that it was specifically from the fans and the design defect?
The expert report came later, but they had a fire, I believe, in September of 2012. Initially, no one made any thought of it because it was so small. The fire started in the fan, exhaust fan in the first floor bathroom. There happened to be a plastic water line over it. The fire melted the line, water came out, doused the fan. $600 worth of damage. By the way, that melted PICC line is damage to other property. 6 months later, we have another fire, second floor, this house burns. Seriously burns, fire department comes, parts of the roof destroyed, the trusses destroyed, attic destroyed, insulation destroyed, carpeting throughout the building destroyed, drywall in one of the bedrooms had to be removed and replaced, lots of damage. None of those things that were damaged have any relationship to the exhaust fan. The economic loss doctrine and the integrated systems theory clearly does not apply here, and the appellate court so found. On the point of getting the second fan, Mr. Keating, who's the health and safety gentleman for Corvias, he put the two together. He knew about both fires. He now knew he had a problem, which is these fans that used to just not work are now catching fire. And that was enough for them, because the motto at Corvias is families first. And they take that very seriously. The welfare and health of the military families of Fort Riley are their top priority. They could not afford another fire. So they turned them off, and they notified the manufacturers. And guess what they said? We didn't sell you. There are no fans of ours there. Those emails are in the record. When we sent them receipts showing there were fans, they said, well, that's only 50 fans. There are 3,500 fans. And so we notified them and said, we're taking them out. You can come and participate if you want. This is mitigation. We couldn't afford another fire. One of the lessons in David versus Head is that we shouldn't have to have bodily injury in order to decide whether we've got a product liability claim or a negligence claim or a strict liability claim. We need to look at the duty owed, and here clearly there was a duty owed. My time's out, so let me sum up and say,
Well, let me first ask if any of my colleagues have any questions. All right, I'll give you the same 30 seconds other council received.
we ask that you would affirm the Court of Appeals. He was absolutely right on with respect to the economic loss doctrine and the integration system theory. And its extension of Wisconsin law was logical and helpful. There's a lot of flack about not applying both prongs of the Wisconsin test. The second prong it didn't apply is the disappointed expectations prong. And I'd welcome you to apply that as well, because that's really the flip side of the independent duty analysis. And it's very helpful here, and it makes it very clear that we've got a product liability claim here. And the appellate court did indeed recognize that under the statute, all, as did Judge Sexton, all of the damages claimed are now merged into one unified claim, and that defendants' efforts to sort of pull the removal and replacement costs out as if they're not valid mitigation costs is unsupported by any Kansas law. Thank you, Your Honors.
Thank you, counsel.
Defendants are not arguing that removal and replacement costs are not recoverable costs. They're recoverable in the contract, however. The cases in the claims in this case are clearly product liability cases. That's what the Court of Appeals said. That's what Judge Sexton said. That's what everybody said.
What's your response to your opposing counsel's hypothetical about an individual who is has personal injury as a result of a defective product and loses work time, has attendant economic loss?
The economic loss doctrine that we speak about as it relates to product liability cases is not that. It has to do with economic loss related to the product itself. Those are wrongful death damages, which will include personal injury, pain and suffering, as well as mileage to the doctor and medical fees.
So you think that is recoverable in a product liability claim?
Under the wrongful death statute, those are recoverable. But the product liability statute and its interpretation by cases after are that 3302D is speaking about economic losses to the product itself, not broader-based economic losses. Broader-based economic losses occur in all forms of negligence, including product liability cases.
I'm just back to the language of the statute. That's not, the statute doesn't say that. It just excludes, harm does not include economic loss, period. So if you read it just on its face, it would tend to indicate that even that plaintiff who had a personal injury and then lost wages wouldn't be able to recover that.
That's not the case we've got here, but I think I disagree. I'm going to read the language if that's okay. Harm includes damages to property, personal physical injuries, which occur under the Wrongful Death Act that we've talked about, illness and death, mental anguish or emotional harm, attendance to such personal physical injuries, illness, or death. The term harm does not include direct or consequential economic losses. In this case, as we know, we're not talking about any sort of physical harm whatsoever. As to the $459,000, we're simply talking about the removal and replacement costs for the product that is a part of this particular case. The Kansas Product Liability Act applies on a much broader base than that, but it most certainly applies to these types of direct and consequential damages as they relate to this case itself. A radical expansion of product liability law would be to declare these bathroom fans to be inherently dangerous. They're not. We only overturn the privity argument, the privity rule under Kansas law in serious situations. I count 14 different things that might cause fire, none of which are inherently dangerous products. The Kansas Product Liability Act applies here. Plaintiff is requesting economic damages, as he has already said, and all of his claims are product liability claims. The Kansas Product Liability Act, as well as case law interpreting it, would say that he is not, that Corvias is not entitled to recover the removal and replacement costs. And pursuant to the integration rule, we believe that they're not entitled to recover the property damage to the homes themselves. Unless there are further questions, I'm through.
I see no further questions. Thank you, counsel.
Thank you, Your Honors. I
We
appreciate
thank all of counsel for your arguments this morning. Court will take this matter under advisement.